Good afternoon, everyone, and thank you for joining us on what it transpires is one of the most momentous days in procurement, more of which in a minute. But a quick spoiler alert, everything has been published this morning that we were waiting for, so we'll be able to cover that off in the session. I'm Andrew Daly. I'm a partner here at Hemsons and also head up our specialist procurement law team. And I'm joined by a couple of the team today, Helen Redfern, who is a senior solicitor, and Maria Gomez, who is a solicitor in the team. We're based around the country within our 5 different offices in London, Manchester, Newcastle, Harrogate and Southampton. And today we will be looking at the Procurement Act. We've got 90 minutes to look at what it will mean in practice for you. And I think there's just some points to note at the beginning. So we do have a mixed audience today. We have suppliers, we have contracting authorities, we have framework providers, we have third sector organisations. So we're trying to cover a broad church of attendees. And also we expect there will be a broad church of knowledge of the Act. There will be some people on here, and I can see their names on the list, who will have done their 10 hours, they will have done their deep dive training, and they will be ready and raring to go. There will be others that this is newer to, and they may be less familiar with some of the details. So we're trying to cover a broad church this afternoon. So hopefully there will be something for everybody. There is a lot of detail in the slides. We're not going to be reading every word on the slides. They will be sent round after the session together with a recording once it's edited, so that you'll be able to see that and have that as a reference. And there will be time for Q&A at the end. If you want to put stuff in the chat, please do. And we will address that either at the end or if it is appropriate as we go along. What we are going to also cover is a lot. The Procurement Act, there's a lot to say about it. Inevitably, we can't cover everything. There are various articles that we have been sending round. There's more to come. We just don't want to send them all on one day about some of the things, because we now are in a position where we really are in the final stretches before the Act comes in. It's also worth noting that a lot of the focus today will be on NHS procurement. We're not specifically going to be looking at utilities, defence, etc. But of course, if there are things that people want to look at on that, then please just give us a shout afterwards. So what we're going to cover today, we're going to do an introduction. What is the current position? What does the Act mean for you in practice? Concentrating on a few things. So Helen will look at ITTs, conditions of participation. I'll look at frameworks, dynamic markets, direct awards. Maria will look at varying contracts and debrief. Helen will look at contract management. And then I'll try and conclude everything, leaving time for questions at the end. So we have been talking about the Procurement Act for what seems like an absolute eternity, and it received royal assent back at the end of 2023, and we've been waiting for it to go live. We of course had it delayed from October last year until February, and we are now 11 days to go. I can't believe we may actually be in a position where we can say the Procurement Act has gone live. It does feel like we've been talking about it coming in for, as I say, for absolutely ages. The Act goes live on the 24th of February. That is a week on Monday. I think the rumours have now finally stopped that it is not coming in on the 24th of February. Did the webinar this time, well, last Tuesday, the original one of these, there were still rumours flying around at that point that it would be delayed. Given everything that I'm going to come on to about what's been published and everything that's in the position for it to go live, it will be going live on the 24th of February. 11 days to go. But I think one of the things that I want to sort of explore with you is the extent to which your life is going to change on Monday the 24th, and we'll come back to that in a minute. I think the thing to stress at the beginning when we are talking about procurement going forward is what is going to be absolutely critical is knowing which rules apply. As I said at the beginning, we're going to be focusing primarily on the NHS here, and so the NHS is in the position of having 3 regimes that will apply to its procurement activity: the Procurement Act, the Public Contracts Regulations 2015, and the Provider Selection Regime 2023. This is a session on the Procurement Act. We're not going to be looking at the PCR or the PSR, but it is worth noting that there are similar provisions in each of these regimes, but all with slightly different requirements. And I'll come to an example of that a bit later. So what will be key is to make sure you know which rules apply. This is particularly important in relation to the PSR, which is covered off on this slide. But before we get to that, what you have to be aware of is that if your requirements are caught by the public contracts regulations, you continue to apply the public contract regulations until the Act comes into force. So if you were to commence a procurement today or next week, you would be running that under the public contracts regulations. But once the Act comes into force, any process commenced after the 24th of February will be run under the Procurement Act rather than under the Public Contracts Regulations. And we'll explore the transitional provisions on the next slide, so what happens if you have a process that's in flight. But the thing I really want to stress here, and something that we are seeing cause a great deal of confusion, particularly on the last webinar as it happened, was around how the provider selection regime is impacted by the Procurement Act. Now, the provider selection regime, as I'm sure you will be aware, is a bespoke regime where relevant authorities are procuring relevant healthcare services, and it came in on the 1st of January 2024. Now, relevant authorities are NHS England, ICBs, trusts, foundation trusts, local authorities and combined authorities, and relevant healthcare services are as defined in the PSR, but broadly healthcare services provided to individuals, whether that's mental or physical health. Now, it's obviously slightly more nuanced than that, but that is the broad position. The Procurement Act does not significantly impact the PSR. The PSR stays as it currently is. So if you are a relevant authority procuring relevant healthcare services, you will be applying that. The only difference is that in some consequential amendment regulations that have actually been signed off by Parliament yesterday, there are some tweaks to the exclusion provisions and the debarment rules in relation to the provider selection regime. But whether or not you're using direct award process A, B or C, most suitable provider or competitive process, isn't changing. The Procurement Act is not impacting how procurements are run other than in relation to exclusion and debarment. And last night we published a podcast and a quick article on this if you want to have a look on our website for any more detail. What we need to then look at is the transitional provisions. And I see there's a question about the Act meant to replace the PCR. And yes, the Act does replace the PCR. But come the 24th of February, it will not be a case that you can burn your copy of the Public Contracts Regulations and never have to consider it again. Because procurements that commence after the Act has come into force will be under the Act, so the Act will apply. But anything that has been started under the Public Contracts Regulations will continue to be awarded under the Public Contracts Regulations. So, if you issue a contract notice today to start a procurement, that procurement will be governed by the PCR, not the Procurement Act. If the notice that you are publishing today is to establish a framework agreement, that framework agreement will be awarded under the Public Contracts Regulations, and any call off from that framework will also be under the public contracts regulations. So if we use my hypothetical example of sending a framework notice today, then the public contracts regulations will still need to be considered for at least the next 4 years. But assume it takes maybe a year and a half to award your framework, and assume that there are call-offs that are happening post the end of that framework. We will still be looking at the public contracts regulations in the 2030s. And this is where it's really important to know which regime applies, because if you are looking at a process in later in 2025, and what you should do next and what notices you should publish, you need to know when that process commenced, because if it commenced before the Act came into force, so i.e. now, then the public contracts regulations rules will apply, not the Procurement Act. Also, modifications of existing contracts remain under the current rules. So if you have a contract now and you want to amend that later this year, the current rules under Regulation 72 apply. There is not a need to consider the new rules that Maria is going to talk about later. What you therefore really need to be conscious of, as I say, is which rules apply, and make sure that you are applying those, and don't just assume that everything going forward will be the Procurement Act. There will be the PCR processes, there will be the PSR processes, and then there will be a Procurement Act set of processes. I just see one of the questions is there a cut-off? If you publish your notice on the 22nd of February, that would still keep you under the PCR. It would only be if you published it after the 24th that you would be under the Procurement Act. It is worth noting that the modification position under the Procurement Act is different than under the provider selection regime. And again, this is why you need to know which regime you're in, because the provider selection regime, any modification to any contract post the 1st of January had to be considered under Regulation 13 of the PSR, whereas we will have under the PCR Regulation 72 and under the Procurement Act for processes that commence after the Act came into force, that will be under the provisions as set out in the Act that Maria will come on and cover. I just want to summarise where we are with the current position, and I will say now that these slides are out of date because everything changed this morning. And if any of you follow me on LinkedIn, you'll have seen that I've put out 3 posts because of the amount of things that have changed. So let's just go back to what the factual position is and look at what has been published this morning and what implication that may have. So the Procurement Act brings all of the public contracts regulations, utilities regs, the defence regs and the concession regs into one place. So if you are looking at the Act, that is where the primary legislation is for all types of public procurement. However, as you will see with the bullet points that we have, that is not the one place you need to look, because there are regulations that sit under it, there's guidance that sits under it. It is also important to note that as of last night, the Consequential and Other Amendment Regulations 2025 were passed by Parliament, and those have already amended the original versions of the Procurement Act and the Procurement Regulations 2024. So we know there's a lot of people out there at the minute looking at saying, here's a hard copy of everything so you can know where to look. Those hard copies, if they've already been printed, will already be out of date. So it's going to be key to make sure you are looking at the most up-to-date version. But the primary place you will be looking for the legislation on procurement is the Procurement Act. You also will need to look at the Procurement Regulations 2024. They deal with a lot of the details, so what goes in the notices, how you calculate horizontal and vertical arrangements, etc. But again, please note that both the Act and the regulations have already been amended. We then have the guidance, and nearly a full set now published. There's 2 left. Well, the 2 of them were published this morning. So what we now have as of this morning is the electronic invoicing and payment guidance and we also have the payment compliance notice guidance. You can't see me because of the blur, but they're both there. So they were published this morning. So we now have our set of 47 sets of guidance that sits underneath the Procurement Act. So what you need to look at when you're looking at how the Act works is what the guidance says about these specific areas. This is the first time we have had so much guidance on procurement, and it will be something that, of course, people will need to look at. If you're not following what is in the guidance, that is something that we are sure that suppliers will look to raise. But we now have that full set of guidance. I also said that on this slide that we're awaiting the new version of the National Procurement Policy Statement to be laid before Parliament. That was published this morning. So here we are again with the statement. Now, if you look in the statement and if you remember, that is the reason why the Act was delayed from October 24 to February 25. If you have a look at what is in that guidance, there are now 5 stated missions to kickstart economic growth, make Britain a clean energy superpower, reduce crime, reduce barriers to opportunity, and build an NHS fit for the future. It is also apparent that there will be a sourcing playbook will be published, and that there is going to be 3 priorities to deliver value for money. So one will be to drive economic growth and strengthen supply chains by giving SMEs and VCSEs a fair chance at public contracts, deliver social and economic value to support the stated missions, and then you need to ensure you have the right commercial capability and standards in place to procure and manage contracts effectively. So we're still working through what that means and what is different from the position now. But it is also worth noting that this morning, and again, the slides haven't been amended to deal with that given when it happened, we've had 2 new procurement policy notes published. So we've had 01 and 02 in 2025. The first is SMEs and VCSEs procurement spend targets. The second, taking account of social value contracts in the award of central government contracts. So the second one, the social value one, updates the 2020 PPN on social value. The main headline is that the minimum 10% weighting for social value remains. But I think one of the things really to stress here is, as you can see, things are changing all of the time. When I went to bed last night, this talk was going to have to be very different than it is now, given what's happened this morning. And it is also worth noting that these documents are being updated. So the guidance has been updated, but it's not obviously stated to be updated in any of the publications. The only way you know is by looking at the document history. So the valuation of contracts guidance, for example, was updated twice in January this year. So you need to make sure you're looking at the latest version. It is also worth noting that there is a lot of documentation that's been published, standard documentation to help you. This is on the procurement pathway. So there are assessment summaries, there's sourcing strategy documents, there's all these documents that are there to help you. Again, note that they are also in the process of being randomly updated, and therefore they need to be considered. The Competitive Flexible Procedure Pack that has been published by the Centre. That provides you with effectively a set of headings and guidance, another 2 sets of guidance that sits under that for you to complete those headings and get your documentation out. So there is information that's out there. It's also worth noting, and this isn't on the slide, is that NHS England last week published a standard set of ITT documents. These are available on the NHS Futures website. There is an open one. There isn't on the procurement pathway, but there is an open one. There is a competitive flexible procurement one. And then there's also below threshold, light touch, etc. The reason we know about those is because we drafted them for NHS England. So they are there and available for NHS organisations to access and use as a central database. If you want to speak to us about those, can you obviously just let us know. And then finally, by way of update, there were two PPNs published at the end of last year. They were PPN 015 and 018 in 2024, and they deal with suppliers' approach to payment in procurement of major contracts. These are PPNs that were published that have not been taken into account in some of the standard documentation that's published, not the NHS England ones, but on the government portal. Those need to be checked to make sure they're up to date for this. So long and short of it, as you join us on the 13th of February, we now have a suite of everything ready for documentation for the Act to go live on the 24th of February, 11 days time. We haven't yet actually got to talking about what's in the Act. We're just going to quickly look at some of the key changes before looking at some of these in a bit more detail. So the Act has new terminology in it. There is, I think, this is what, for me, is going to be the source of potential problems for organisations because the terminology does different things depending on which regime you're in. So, for example, a contract award notice under the Procurement Act starts a standstill. Under the Public Contracts Regulations, it's a notice that's published within 30 days of the contract being awarded. Under the Act, that is now a contract details notice. So there's a lot around terminology, and we'll cover some of that when we get into some of the detail. Helen's going to look at the new procedures, but there's open, competitive, flexible, and direct award. We're going to come back to that. Most advantageous tender replaces most economically advantageous tender. In reality, for the NHS, that is going to make no difference unless you were evaluating on lowest price. But in the 20-odd years I've been doing procurement, I've never evaluated purely on lowest price. There's a massive increase in notices. We're not going to cover all of that during the session today. And there is also new provisions on exclusion of bidders and debarment. We're covering some of that, but not all of it. I'm going to talk about dynamic markets and frameworks. Maria will be talking about standstill. We're not specifically covering remedies. There will be an article coming out shortly on the implications for remedies, but broadly the position is the same, just with different terminology. There may be some nuances around when the automatic suspension remedy is available, up to and when, but we're covering that off in the article, and more will follow. Without wanting to short circuit the article, we really need to wait for a decision of the courts as to how one thing will work in practice. We're going to cover off modifications. Conflicts of interest, there is more detail needed in conflicts of interest under the Act, and you'll need to consider conflict assessments, keep those up to date. And then we're going to touch on contract management. There's a lot of changes in relation to contract management under the Act. And one of the things that we will see when Helen comes to talk about this later is that historically procurement was about awarding a contract and then that was it. Procurement then had a role if contracts were being varied because of the rules around material variation. Now procurement needs to be involved in the complete life cycle because there is a need to manage performance of contractors and publish notices if there is not good performance. There are, though, a number of similarities in the Procurement Act to the Public Contracts Regulations. So who it applies to, the fact there's thresholds, you'll still need to consider CPV codes. There's underlying principles, they're slightly different, but in reality broadly the same. You still have to run processes, you still have limited ability to vary contracts, you have limited grounds to make direct awards. There's still going to be a risk of challenge, there's still remedies available, and there's still a period within which challenges have to be brought, the limitation period. So what you find is a lot of the steps are the same under the Procurement Act. What is different is the detail. And I just want to give you one example to really show, and this is something that you'll see throughout the rest of this session, the devil is in the detail, and you'll need to check the requirements carefully. So, does anybody know when St. Andrew's Day is? I find that most people know the answer to the second one, when is St. Patrick's Day, but they don't know when St. Andrew's Day is. So well done, people in the chat. Thank you. So yes, St. Andrew's Day is the 30th of November. The St. Patrick's Day is 17th of March. The Northern Irish get 2 more bank holidays than those in England and Wales. And why do you need to know this? Well, let's just look at the standstill period. The standstill period is 8 working days. However, if you look at the detail as to what is the definition of a working day, it is a day other than a Saturday or Sunday, or a day which is a bank holiday in any part of the UK under the Banking and Financial Dealings Act 1971. So this means that you'll need to factor in all the bank holidays in England, Wales, Scotland and Northern Ireland when calculating the standstill period. So if you were running a process under the Procurement Act, the standstill period was running at the end of November, start of December this year, you would not be able to count the 1st of December as one of your 8 working days. That is because Monday the 1st is a substitute bank holiday for Sunday the 30th, which is St. Andrew's Day in Scotland. So if you were, unless you were a brownie, by the looks of what Joy has said in the chat, the other way of doing that is if you go onto the government website, type in bank holidays, there's a button that adds it to your Outlook calendar. And that will need to be, and if you're like me, when you're working the standstill, you look at your Outlook calendar and count aloud. You need to make sure you're looking at the days so that you can see if, when, for example, the Battle of the Boyne is, etc. And this is some of the areas that are likely to cause issues, because if you do not comply with the standstill period, of course, you will not have got a compliant standstill to be able to move to award. And just to give you an example of the 3 different regimes, if we look at the position under the public contracts regulations, you notify bidders by writing to them to tell them who's won and who's lost, the debrief letters. And if we did that on the 15th of January, the standstill period would end on the 27th because you'd be using 10 calendar days. You'd be able to sign on the 28th. If you were using the PSR, you'd publish a notice to tell bidders on the 15th of January. Standstill period is 8 working days. But if you published a notice today, your first working day would be Monday, not tomorrow, because of how the PSR has been drafted, which means the standstill period would end on the 28th. You could sign on the 29th. If we assume, for the sake of this argument, that the Procurement Act was in force in January, but if you publish a notice under the Procurement Act, which would be a contract award notice on the 15th of January, the standstill period would end on the 24th of January. So you could sign on the 25th, which is a Saturday. Most likely you would sign on the 27th. So under the 3 different regimes, publishing a notice on the same day or publishing the notification on the same day, depending on which which regime you're in, you have different dates for when the standstill period ends. And in those examples, that doesn't even include the bank holidays that we raised earlier. So really, that is a prime example of showing why there is a need to look at the detail, know which regime you're in, and really check what the requirements of that specific regime are. Hopefully that gives an introduction to where we are. I'll hand over to Helen now to look at some of the specifics in more detail.
Thanks, Andrew. So no doubt those of you who are working at contracting authorities have already started thinking about your standard tender documents, whether it's because some of you might have started updating them already, and maybe there's some of you who haven't started at all. So we're going to have a little look at updates that you might be making to your ITT packs. As Andrew's touched on earlier, when it comes to the overarching principles, the good news is that a lot of them are very similar. So, for example, you still need to clearly set out what it is that you're planning to do and then stick to it. and you'll be taking many of the same steps when you look at it at a high level. So you'll be running a competition where you're inviting tenders, you're assessing those tenders, and you're identifying the successful tenderer. But there are important differences in the detail. So you will need to work through methodically, looking at your standard tender documents for any process that you plan to run under the Act and make any necessary updates. So as a starting point, a good place to think about is which procedure are you going to use? So under the PCR, we had 5 different procedures available, but that's now been reduced to 2 with some more flexibility. So the first option you've got is the open procedure, which is similar to that under the PCR in that it's a single stage process. Anyone can submit a tender, and it might be that that's going to be the most popular one, like it has always been under the PCR. But then you do have the second option, which is the competitive flexible procedure. That replaces the other 4 processes that were available under the PCR, and we've listed those out on the slide for you. And that one gives you a little bit more flexibility to design your own process that you think will be useful for your particular requirement. I mean, at first, what we are expecting to see is that people are going to replicate what was available under the PCR because it's familiar, but who knows, you might see someone sticking their head above the parapet and doing something new. Just a note on light touch contracts as well. So if you're procuring any of the services that are listed in Schedule 1 of the 2024 procurement regulations, so broadly those are social, health, education and other public services. And when we say health, we're not talking about relevant healthcare services that are caught by the PSR. So the light touch rules are different to the way they were under the PCR. You no longer got a separate set of rules that apply to light touch contracts. And if you're procuring an above threshold light touch contract, then you need to comply with the rules of the Procurement Act generally, with some exceptions and some special provisions like a higher threshold. And you will need to choose from and comply with the open or competitive flexible procedure. Whichever procedure you choose to use, you need to be satisfied that it's a proportionate way of awarding the contract. And when you're thinking about what's proportionate, the factors that you need to think about are the nature, complexity, and cost of the contract. So that's a good place to start, because when you're designing your ITT pack, you'll be designing it with that procedure in mind. In terms of the detail of what you're going to look for in your ITT, ultimately you are going to have to work through it systematically. Now, we haven't got enough time to go through all the possible amendments that you might be making. So what we've tried to do instead is pick out some things that you could think about when you're looking at it yourselves. So a good starting point is to familiarise yourself with the new language under the Act, like Andrew's mentioned. And we've given you some examples of the changes to the terminology that you'll see on the slide. So evaluation becomes assessment, selection criteria become conditions of participation. So you should be aligning your ITT with that terminology. Another thing to look out for is any new provision and requirements. So one thing you might want to have a look at is Regulation 6, the Procurement Regulations 2024. So there's a little bit of an explanation. Under the Act, suppliers are going to be able to submit information via the Central Digital Platform, which is an enhanced version of the Find a Tender service and is essentially a single place where you are going to publish information about procurements if you're a contracting authority. And if you're a supplier, you can submit commonly used information just the once and keep it up to date rather than having to submit it time and time again. So what Regulation 6 does is where you're running an open or a competitive flexible procedure, you need to obtain confirmations from suppliers that the information they've provided via the Central Digital Platform is up to date and accurate. And you do that before the end of a tendering period and then again before contract award. So when you're updating your pack, you'll need to have a think, Where are you going to get these confirmations? Are you going to gather them in a questionnaire or in your form of tender, for example? And also, are you going to reflect this in your ITT? So are you going to explain that you're going to be doing this, when you're going to do it, and what happens if information isn't provided? Another example of something to have a look at is lot. So under Section 18, you've got a positive obligation to consider whether goods, services or works could be supplied under more than one contract and be awarded by reference to lot. And if they can, you need to split it into lots or explain why you haven't in your tender notice. So again, that's something you might be explaining in your ITT. Another thing that you'll need to check carefully in your ITT is the timetable section. So Section 54 of the Act sets out a number of factors that you'll need to consider when you're setting time limits, but it also sets out some minimum timescales for participation periods and tendering periods, which are different depending on the type of contract that you're procuring, the circumstances, and what kind of contracting authority you are. Generally, they're all a little shorter than under the current legislation, but that's something that you'll have to make sure that you're complying with. And as Andrew's mentioned, you need to carefully calculate your standstill period and make sure that you're getting it right in that timetable. Another thing you might think about including in your ITT is, are you going to warn suppliers about the new requirements that apply to you as a contracting authority? So examples are exclusions. So you're going to explain to them at what stage you'll assess exclusions and what you'll be doing to do that and what will happen as a result, because you shouldn't necessarily expect them to know what you're going to do, even though it's in the Act. Another thing that you might want to include is, even though you're going to include a draft contract in your pack, whether you flag the contract management measures to suppliers in your ITT just to really draw their attention to it. One of the key documents that you're going to be working on in your pack is your specification, which, as well as being a critical document for any procurement, is also subject to the requirements in Section 56 of the Act. So you need to design performance or functional requirements when you're drafting it, and not designs, licensing models or descriptions of characteristics unless it's inappropriate to do so. If you need to refer to any standards, you need to refer to international standards such as ISO, or UK standards that adopt international equivalents like BS ISO. And then only if those don't exist can you specify other UK standards. But if you are, then you must accept overseas equivalents. And unless it's necessary to make your requirements understood, you can't refer to trademark, trade name, patent, design or type, place of origin, or producer or supplier. If you do decide that it is necessary to refer to those, then you'll need to provide in your tender documents that tenders demonstrating equivalent quality or performance will not be disadvantaged. So another thing that you'll be thinking about when you're designing your process is conditions of participation. So those replace the selection criteria under the PCR, and they're defined as a condition that a supplier must satisfy if it is to be awarded the public contract. So they're similar to the PCR in the sense that they assess the supplier rather than the supplier's tender. They are permitted to relate to two types of subject matter. The first is a supplier's legal and financial capacity to perform the contract, and the second is the supplier's technical ability to perform the contract. So you'll see there, both of those are about ability to perform the contract. So these are conditions that need to be relevant to the contract itself. You also need to be satisfied that they are proportionate. So when you're thinking about proportionality, you're looking at those same factors again. You're having regard to the nature, complexity and cost of the contract. And it's important to remember that where a supplier doesn't meet the conditions, then they can't be awarded the contract. So at the moment, selection criteria is something that we do see causing issues under the PCR, and it's something that will be important to get right when you're preparing your process under the Act. When it comes to designing your conditions, when you're preparing them, try and make sure that they're clear and concise so that they can be understood and applied by suppliers and your assessors, and set them at the right level, bearing in mind that a supplier can't be awarded the contract if it doesn't meet the conditions. You know, are you going to be aiming to include only essential minimum requirements so that you're not setting them at too high a level? You also need to make sure that any conditions you design comply with the requirements in section 22 of the Act. So when you're thinking about legal and financial capacity conditions, you can't require audited accounts from suppliers who don't have to have their accounts audited. And although you can still ask suppliers to confirm or provide evidence that they will take out insurance on contract commencement if they're successful, you can't require them to take out insurance before contract award. When it comes to technical ability, you can include qualifications and experience and technical ability as requirements, but you can't require suppliers to have been awarded a contract by a particular contracting authority. You need to make sure that your conditions comply with the technical specification rules in section 56, and you can't require particular qualifications without allowing for their equivalence. So when you're designing your process, another thing that you'll want to think about is how best you're going to use them in your process. So when are you going to assess them and what effect do you intend for them to have? So, for example, in an open procedure, are you going to use them to exclude suppliers before you take time assessing the rest of their tender so that you're saving your time and that of the supplier? In a competitive flexible procedure, are you going to use conditions of participation to restrict who can submit a tender? And if you're taking that approach, are you going to use pass-fail conditions? Or if you're whittling down suppliers, are you going to use scored questions and then take through, say, the top however many? And in that case, what are you going to do in the event of a tie? So those are all things to think about when you're designing your process. Another thing to remember is associated persons. So remember that a supplier is to be treated as meeting a condition where an associated person does. An associated persons is defined in section 22 of the Act. So broadly, suppliers are associated where they're submitting a tender together, or you're satisfied that the suppliers will enter into legally binding arrangements for subcontracting or guarantees. So that's something that you should include in your tender documents. One thing that we've been asked about quite a bit is below threshold procurements and conditions of participation. So you can't restrict submission of tenders by reference to an assessment of suitability, but you can still request suitability information from suppliers and then assess it at award stage. There is also an exclusion for below threshold work contracts, which have an estimated value at a certain level. The next thing you'll be thinking about when you're building your pack up is how you're going to design your questionnaires to gather the information that you need to assess your conditions of participation. So you're no longer required to use the standard SQ, and the government commercial function has published the procurement specific questionnaire. Now that is only a starting point. You will need to work it up for your procurement. So you'll need to add questions that are relevant to your conditions. You'll need to add any criteria that you're going to be applying. And you also need to review the PPNs and ensure that you've got questions to comply with those. In terms of the central digital platform, have a look at what information is going to be gathered there, such as economic and financial standing information. Think about what your requirements as an organisation are and whether that information is going to be sufficient. And if it isn't, then think about what information you need to request and how you're going to do that. Also, the Cabinet Office has indicated that the Central Digital Platform is going to be expanded in the future to try and address any commonly requested information, so things like Modern Slavery Act questions. But for now, they have published what is going to be there. So I'll pass you back over to Andrew to talk about framework.
Thank you, Helen. And go on, Simon. We'll let you squeeze a question in.
Helen, firstly, thank you very much. I will be brief. Just where you were looking at what we can and can't ask for, how do we introduce with the requirements of UKCA marking and the requirements of UKCA marking with some of the medical devices and clinical devices, if we can't specify more appropriately? Or I may have misheard what you said.
So
that is a hard question.
So I think so. I mean, you'd still have to have or equivalent, but there won't be probably an equivalent standard. So it's perhaps something to look at specifically.
Okay, thank you. Thanks, Helen. I'm glad I didn't get it wrong. I'm glad I asked the question.
Okay. Framework agreements, because of course what Helen has just said is running your standalone procurements, but we all know that the vast majority of services and supplies that the NHS buys on a daily basis is done on frameworks. And I said at the beginning that I would talk about whether or not your outlook was going to be vastly different when you go home on the 21st of February as compared to the morning of the 24th. And this, I think, is where the example of it won't change that much unless, of course, you're starting a procurement on the 24th of February. Because if you are calling off an existing framework, then you will continue to be using the public contracts regulations rather than the Procurement Act. So framework agreements, when we're looking at what is required under the Procurement Act, is at least a few months away. Because in order for this to be relevant, a contracting authority will need to establish a framework agreement post the 24th of February, and then you will be looking to call off from that framework later this year, early next year, depending on when it's awarded. And so actually the framework agreement section here is something that I think we'll need to come back to in a few months' time when we're a bit closer to this happening. But it is worth just highlighting some of the high level issues, because if you are establishing a framework, then you are doing that in broadly the same way as you are doing that now and in the same way as other public contracts. The big change is whether or not you're going to have an open or a closed framework. An open framework being one that will be up to 8 years in duration, where new suppliers can join at set intervals during that framework, or a closed framework that is up to 4 years. Come back to that shortly. When you're establishing a framework agreement, you will need to make sure that the framework contains various minimum information. And a lot of this will be, I think, expected, given some of the questions you need to ask yourself now. So the framework will need to set out a description of the service, goods or work. You'll need to set out the price payable, mechanism to determine price for when the framework's awarded, the estimated value of the framework, the call-off methodology, how long the framework's going to be for, who and which contracting authorities are entitled to use it, and whether or not it is an open framework or not. A framework may not permit the award of a contract to an excluded supplier, and a framework may not prevent a contracting authority from requesting additional information from suppliers before awarding a contract. So if further information is needed, then that information should be able to be requested. Now, frameworks can only be established by contracting authorities. When they are establishing a framework, a contracting authority will need to establish the conditions for participation. It will need to determine the term. So is it going to be a closed framework, maximum 4 years unless you can justify longer, or as we have now, or open, a maximum of 8 years where it's opened at least once during the first 3 years and each period of 5 years beginning with the day after the award of the second framework in the scheme. I think if people are establishing open frameworks, they are likely to do this on an annual basis to allow new people to join. I think the question that is really one for framework providers is the extent to which they will use open frameworks or not. Because, of course, reopening a framework comes with an admin burden, both for you as the contracting authority establishing the framework and also for the suppliers. So if you have a market which has a limited number of suppliers that hasn't changed, there's unlikely to be new market entrants, why would you go to the effort of establishing an open framework when you could just use a closed one? If you're looking at something that's an innovative area, then you might want an open framework so you can get new people joining and therefore look at developing that framework. That's one that we'll have to wait and see. There's no limit to the number of suppliers you can have on a framework, but it is worth again noting that devil in the detail. If you have an open framework, so wanting it for 8 years, but you only have one supplier on it, the maximum duration can only be 4 years, even though it is an open framework. Main thing for people on this call calling off frameworks, contracting authorities can only award call-off contracts under a framework established by a contracting authority. So that's something that needs to be checked, that they are a contracting authority. You're then running mini competitions or direct awards. Now, I appreciate under the Act, the language is with or without competition. But colloquially, I think we still will talk about running mini competitions or having a direct award under a framework. You are reopening competition where, unless a direct award is clearly provided for, and to have a direct award, so without opening competition, the framework must set out the core terms of the call-off and prescribe an objective method for supplier selection. One of the big things to be aware of, though, with the frameworks is when you are calling off a framework, you will need to publish a contract details notice. That is the equivalent of a current contract awards notice. So if you are procuring a lot of things under frameworks, there will be an increase in the number of notices that are required. But the good news is you still can call off beyond the term of the framework agreement. So that's something to come back to, given that that can't happen overnight on the 24th of February, because of course there would need to be a Procurement Act framework established. I just want to talk about dynamic markets quickly. These are seen as the replacement for the dynamic purchasing systems, but they are different and need really to be looked at. They should only be for above threshold contracts, but dynamic markets are not public contracts. Instead, they're a list of qualified providers. Now, if you are establishing a dynamic market, you will need to, as the slide sets out, follow the bullet points. So you'll need to make sure you set out your conditions for membership, how it's going to be done, what the notice is, when people can join. They should be able to join at any time. And if people request to join, you should consider their applications within a reasonable period. You need to admit someone onto the dynamic market as soon as reasonably practicable if they're not excluded or excludable. You tell them the position. You can have as many people on there as you like. You can't modify your conditions for membership once they've been published. And you can have these dynamic markets for as long as you like. You can, however, exclude people if they become, or remove people if they're excluded or excludable. To use the dynamic market, you need to run a competitive flexible procedure. Now, the competitive flexible procedure to award from a supplier effectively is a shorter version of a standard competitive flexible procedure, and you will be able to limit it to whoever is on the dynamic market. I've got to say, at the minute, I can't see what dynamic markets are going to be used for. But I have been wrong before, and so I could be wrong again, and they could be used and be the way to go for how things are awarded. I think if you look at the guidance, that suggests that these are likely to be used where there's areas where there's innovation, so that people can be added to the list and be able to be awarded contracts under it. But we'll just have to wait and see. I do think there's some nuances that again have to be ironed out. So, for example, if you are a supplier and you're not a member, then you can't participate in the competitive flexible procedure. But if your application is pending, then you should have that application considered before you make an award under the competitive flexible procedure. So there'll need to be that communication between those who have set up the dynamic markets and those who are looking to award under a dynamic market. But we'll just have to wait and see. Then just want to talk about direct awards. So this is not in relation to frameworks. This is in relation to awarding what we would use now as the negotiated procedure without prior publication of a notice, the negotiated procedure without notice in effect. So where you award a contract to a supplier without any form of competition. You will still have the ability to do that under the Procurement Act, but you will still have the limited grounds upon which that can happen. You may not award to an excluded supplier unless there are overriding public interests in awarding the contract to that supplier. You will also, if you are looking at making a direct award, need to consider if they're an excludable supplier. Now, the grounds for the grounds to make a direct award are set out in Schedule 5. One of the things that you will notice about the Act is that there is very much a different way of drafting than the public contracts regs, in that you will have the specific section of the Act, and then there'll be the schedule that has some of the more detail about that section. So that here, this is Schedule 5. And so there are grounds. The urgency ground is still limited to something that is truly urgent, etc. And there are areas here that will need to be explored as we really get into the detail. There's a new one to protect life that obviously follows the pandemic. But this is where you really need to look at the detail. Yes, I'm going to say devil is in the detail yet again. But if you look now at the public contracts regulations, the third sub-bullet point there, additional or repeat goods, is in the public contracts regulations 2015. If you look at the guidance, it says the provisions are the same between the public contracts regs and the Procurement Act in the Act. However, the Act talks about repeat goods, services, or works. Therefore, the Act is actually broader than the public contracts regs, even though it suggested it is the same. And again, that's why you need to look at the position. The big change really to highlight is that there is a greater need for transparency. So currently, what you are needing to do is decide whether or not you publish a voluntary ex-ante transparency notice to avoid the first ground of ineffectiveness. What you will have under the Act is a need every time you make a direct award to publish a notice, a transparency notice, to say that you are going to be making that direct award. And in most scenarios, you're going to have a standstill period as well. Now, I'm not suggesting for 1 minute that a lot of NHS contracts are awarded when they shouldn't be without competition, where SFIs are waived and contracts are simply awarded. But a lot of the tactics at the minute are that these contracts are awarded and we hope nobody notices because there's no publication in relation to that contract. Obviously, going forward under the Act, if you're having to publish a transparency notice and have a standstill period, that is something that is going to be, there's going to be greater transparency, more people will see what you're doing, and therefore if you can't justify it, then that is going to be a problem for you. I think the big thing here, and I'll come back to this at the summary at the end, is it's making sure that you as the procurement teams make sure that your internal stakeholders are aware of this, so that boards or consultants don't sign contracts without involving procurement, etc., and then you falling foul of these requirements. So I'll now finish on direct awards because I think that is going to be a big change, and hand over to Maria to talk about varying contracts.
Hi, thanks, Andy. Good afternoon, everyone. Hope everyone's doing okay. I know we're quite far down the line of time. So, as Andy said, I will be discussing the variations under the Act. Please note, as Andrew mentioned, the transitional arrangements. So, if you have a contract awarded under the PCR, then the modification regime under the PCR will apply. If you award a contract under the Act, then you would be applying the modification regime under the Act. This goes obviously with the PSR. You'll use a modification regime under the PSR. So overall, there are 10 grounds under the contract that allows modifications to be permitted, and they are set out in regulation in Section 74 and Section 8 of the Act. There are 4 new grounds. and the Act then retains the existing grounds but with some amendments. Section 74 also expressly permits contracting authorities to modify light touch regimes. So what has actually changed? And as I previously mentioned, there are 4 modification grounds which are new, 2 of them which are specific to defence authority contracts, which today I won't have time to go into, and I think they're quite be irrelevant for the audience today. But the other 2 grounds which I will discuss is to do with the urgency and protection of life, which permits modification of a contract where the instances could alternatively be achieved by direct and award a contract under section 41, that deals with direct awards in special cases, and where the following justifications of a direct award apply for those situations in regards to extreme and unavoidable urgency or direct award to protect life. The other new ground is for materialisation of a known risk. So contracting authorities here have the ability to modify a contract based on the materialisation of a known risk, where this could potentially affect the performance of the contract and where the contracts or the risk is unknown. This will often probably be referred to as a known unknown risk. This might be a useful exception. However, you'll need to plan this in from the outset of your procurement and include it in your tender, as well as any transparency notices for award. So I'm not sure how helpful all this will be and what exactly they'll be looking for. I think at the moment they're using it for building works in asbestos cases where there might be a risk, but we don't know what the impact of that risk may be. The other grounds that are available are under our Regulation 72 of the PCR. They have been retained within the Act, but with some tweaks. You might know these as the modification that is provided for in the contract, or where a modification has arisen due to unforeseen circumstances. There's also the modification for additional goods, services, or works provided in the contract, and where the modification is to enable the transfer of the contract on corporate restructuring. The main difference to these grounds is how the 50% amendment value cap is calculated. As you may know, within the PCR, the 50% amendment value cap is below the 50% of the original contract value. In the Act, this is now the estimated value of the contract immediately before the modification. So, for example, where a contract was originally valued at £1 million, during its term, its value increased due to the inflation and additional services where required. So we're assuming that the contract was amended due to the inflation. So currently the value of that contract is now 1.5 million. There is now a proposed modification which is required by the contracting authority and is valued at 60,000. So under the PCR, this modification would not have been permitted. Obviously, for obvious reasons, 60,000 is greater than the 50% of the original contract value under the PCR. But within the Act, because it's not greater than 50% of the value now, then the amendment would be permitted. So this will allow a bit more flexibility. There are other changes in which should be considered when making a modification under the Act. So there are additional transitional transparency requirements. So before a modification of a contract is made, a contract change notice must be published. Within 90 days of executing the modification, you must publish a copy of the contract as modified or modification itself if the publication of the contract change notice is required and the estimated value of that contract is more than 5 million. There is this new introduction of a convertible contract. So when you have a below threshold contract where the when you have a below threshold contract, if a modification is made and takes that value of that contract above the relevant threshold, then that would be deemed as a convertible contract. You will need to take care in this. So if a modification is taken place, you will then need to consider the Act, and you will need to set up the KPRs, follow the contract's modification regime going forward, publish any information about payments, and any termination notice when the contract is ended. So overall, unfortunately, in my opinion, an opportunity to make more significant enhancements to the changes to the modification grounds have been missed. And the regime continues to be as complex as the regime is under the PCR. I will now go through some key points regarding the assessment summaries. So these are currently referred to as standstill period, standstill or debrief letters. It's setting out contracting authorities' tender assessment in accordance to the assessment methodology. It will also set out the tender, how it was assessed against the award criteria by referencing the scores, including any sub-criteria scores. The unsuccessful tenders who have submitted the assessed tender will also receive information about the most advantageous tender submitted in respect of that contract. There are some important differences to the Act compared to the PCR, which we consider that you should note. So when do we need to use the assessment summary? So you will need to provide an assessment summary to any assessed tender. I have provided the definition on the slide, but in essence, it's a tender that was submitted and evaluated to determine the MAT. So you will not have to provide an assessment summary where for bids that were excluded or disqualified at any stage of the tender process. So this might happen, for example, when you use a competitive flexible procedure and that there are multiple assessment stages. So the tenders that are assessed at the final stage will qualify as an assessed tender, and that's when you will give those suppliers with those assessed tenders their summary assessment. So we need to provide an assessment summary to suppliers who have submitted an assessed tender, and there might be different instances and circumstances in which you may or may not have to provide an assessment summary. So for example, for both an open or competitive flexible procedure, you must provide an assessment summary to each supplier who submitted an assessed bid, bearing in mind of what I previously discussed in regards to what stage and the definition of the assessed tender. For frameworks, you will have to provide an assessed summary, but when you're establishing the framework, but no when you're calling off. However, guidance does say or suggest that it would be best practice to do so. For dynamic markets, no when establishing the dynamic market because it's not deemed as a public contract. However, when you're awarding a public contract within a dynamic market, you will. And this is because the contracts are awarded through a competitive and flexible procedure. For obvious reasons, below threshold, you won't need to, as these contracts are below the financial procurement threshold in order for the Act to apply. So what information is required within the assessed summary? So you must include the award criteria, the assessment methodology in full or in summary, or you must indicate it as to where it's located in your tender pack. Any scores assigned to each award criteria. This includes any sub-criteria used when assessed, the reasons for the score, and the relevant and referencing any relevant information in the tender. When the tender was unsuccessful, a further explanation as to why the tender was unsuccessful, including where the tender was disqualified and the reasons for that disqualification. Any unsuccessful supplier must be provided with scores and reasons in respect of the successful tender. So what does this mean in practice and as a guiding principle? The assessed tender should be recognisable from the information provided. So the supplier should be given sufficient information to understand the scores awarded without contracting authorities needing to reference any sensitive details about the supply solution. There isn't a requirement to include a direct comparison between the winning and unsuccessful bidders. The unsuccessful bidder must receive a copy of the information provided to the successful supplier. Any confidential information must be redacted, and there should be an explanation as to how its tender scored against each of the criteria. So this will allow the supplier reading two sets of information side by side, ascertaining the relative advantages. So you will really need to consider the sensitive information. This might be quite an administrative task to do, but quite important to do so. So contracting authorities cannot simply repeat the award criteria and state, for example, your tender demonstrated X or failed to demonstrate Y, because reference will need to be made to the tender. I have set out an example on the slide that you might want to consider. It might be a more appropriate approach as to how you want to set the rationale. So the tender demonstrated all necessary requirements to achieve a score of 5. It provided in section X of the tender the necessary details to give the authority confidence that requirements A, B or C will be delivered, including, and then you would insert information in the tender relevant to the requirements demonstrated. Next slide, thanks, Andy. There are some cases in which the supplier may not understand why a particular score was determined without an explanation of why a higher score was not awarded. Providing this information is best practice and assures the suppliers that their score was correctly provided. It may be that to achieve a higher score, the tender must have demonstrated additional requirements. So in explaining why the higher score was not awarded, the contracting authority should acknowledge that which of those requirements it failed to demonstrate and why. I have set out an example below within the slide as to what might be a more appropriate way of putting it. You can read when the slides are circulated. So when do contracting authorities have to provide the assessment summary? So you must provide an assessment summary to each supplier at the same time, but this must be done before the contract award notice is published. So this is important, as now the publication of the contract award initiates a standstill period, whereas as we all know in the PCR, the standstill period would be initiated when the standstill and debrief letters are provided to the suppliers. The Act does not state any particular time frame between the provision of the assessment summary or the publication of the contracts award. So it's for contracting authority to decide themselves. It is anticipated that in most circumstances the contracting authority will publish the contract award notice at the same time as the assessment summary. This is assuming that they are provided electronically. It should be carefully considered as to when, if you're going to do this at a different time, as to when best suits the contracting authority. And it's one of those catch-22 situations where if you provide the summary assessment before contracts and award, are you allowing the suppliers to read more detail as to, and not starting that clock as to when you are actually providing them the summary assessments and the contract award notice and just giving them that small window of having to review their document. So in preparation and practice, it's important that you set some clear and measurable criteria for awards, provide detailed assessment methodology, train your assessors and train them on the assessment method and the process that the contracting authority is doing. Give assessors template forms for scoring and rationale forms, and explain how they can use them and how they may reduce and the need of redacting commercial sensitive information. Set up good record keeping practices. There is a downloadable template available online, which may assist. Ultimately, the aim was to ensure the process would be less time consuming for contracting authorities and to give greater clarification to the content of the pre-standstill communication. This may be the case with the removal of the previous requirements and replacing it with a requirement to simply reproduce information in respect of the MAT tender. However, for unsuccessful bidders looking to challenge the outcome, the assessment summary will likely still present a start of a long process of requests for disclosure of internal documents containing the underlying reason for contracting authority's decision. So hence the importance of good record keeping. So for those reasons, I mean, we or I still consider that there will be a continued risk and being continued to be a higher risk area. Thanks, Andy. I'm now going to pass you on to Helen, who's going to discuss contract management requirements.
Thanks, Maria. So this is something where Andrew did a little bit of a trailer for me earlier on in the webinar. And as he said, this is somewhere where you're going to see a bit of a change, because at the moment, the procurement team is done with it once the contract's awarded, pretty much. But under the Act, there's going to be requirements imposed over the whole lifetime of a contract. So it's likely that other people within your organisations, if you're a contracting authority, will need to be involved and will need to know about some of these measures. So one of the key changes is if you are awarding a contract with value greater than £5 million, with some exceptions set out in the Act in the detail, you will need to set at least 3 KPIs. You need to publish details of the KPIs in your contract details notice, or you need to explain why they haven't been set if it wasn't appropriate to do so. Then, during the life of the contract, you need to assess performance at least annually and on termination of the contract, and you'll need to publish details of that assessment and the outcome of the assessment on the central digital platform using a contract performance notice. You'll see that in the regulations there are some standardised performance ratings that we've set out on the slide for you. So if you've got an internal scoring methodology, which you might do depending on the KPI, then you need to align that internal scoring methodology with those standard ratings. And that's something that you might want to agree with your supplier and document in your contract so they know exactly what's going to be published. You also need to keep your KPIs under review during the contract, and if needed, you will need to amend them as long as your contract permits you to do so. Another key change is that you will need to publish information regarding poor performance and breach of contract within 30 days of the event arising under section 71(5) of the Act. And there's 2 triggers. We've set them out on the slide for you. The first is where the supplier has breached a public contract and the breach results in termination or partial termination, an award of damages or a settlement agreement. And the second trigger is if the contracting authority considers that the supplier is not performing to the authority's satisfaction, they've been given opportunity to improve their performance and they've failed to do so. So that second situation is a subjective assessment on the part of the contracting authority. So if those circumstances arise, there's 2 potential notices that you might need to publish if you're a contracting authority. The first is if a breach doesn't lead to full termination, then you would publish a contract performance notice. If the breach does lead to full termination of the contract, then instead you'll be publishing a contract termination notice. What you'll see if you have a look in the regulations for the information that you have to include in those notices, both of them include quite extensive information. And we've given you some examples on the slide. It's the result of the breach, an explanation of the breach or failure to perform, the amount of any damages or monies paid, and a link to any court or tribunal decision. So as you can imagine, that is quite a change, because at the moment where there's been a breach, that will tend to be relatively private as between the parties if proceedings aren't issued. So clearly that's going to have some quite significant consequences for suppliers going forward. Slide please, thanks. So there is likely to be a reputational impact for suppliers because any breaches will be a matter of public record, but there are other knock-on effects. So there's a new discretionary exclusion ground in paragraph 12 of Schedule 7, and that captures suppliers where a contracting authority has published information under section 71(5). So that is the breach or poor performance information that we've just talked about. That means that other contracting authorities in subsequent procurements might disregard a tender, exclude the supplier, not make a direct award, remove the supplier from a dynamic market, or exclude a supplier from participating in a call or competition. And if a contracting authority does exclude a supplier on that basis, then they will need to notify the PRU, who will investigate and, if appropriate, could add the supplier to the debarment list. So it could also lead to suppliers being added to the debarment list. Also, as a further knock-on effect, there are implied termination rights in section 78 of the Act, and some of those will apply where a supplier or associated person or a subcontractor of the supplier has become an excludable supplier since the contract award. So what that means is that other contracting authorities could gain termination rights that they might choose to exercise. So clearly, we think this is going to be a contentious area because you already find that parties will disagree about poor performance or breaches when they arise. This is something that ideally, whether you're a contracting authority or a supplier, you probably want to avoid things reaching that point. So if you're a contracting authority, you could try and avoid it by making sure that you're robustly managing your contracts early. And if you're a supplier, again, proactively monitor your compliance with your KPIs, try and address issues early to try and head problems off at the pass. Also, this is something, if you are a contracting authority, you probably want to approach this with caution. So think carefully about whether the duty to publish has actually arisen, and if so, what information you need to provide. It's something that you might want to bear in mind if you're settling a dispute, in terms of the terms of any settlements, such as terms around confidentiality and whether they'll cause an issue with this. And in a wider sense, the contract management obligations fall within the definition of covered procurement. So contracting authorities will need to comply with the objectives in section 12 of the Act when they're taking steps in this regard. So I will pass you back on to Andrew.
Okay, so just to try and finish up to give some time for questions, obviously with things happening this morning, that took a bit longer than normal, so we're running a bit short of time. So key issues to prepare for. The knowledge. Look, you're attending training, you need to know which rules apply. I've said that a lot in this session. I think the big thing is the internal awareness, making sure that people within your organisations are aware of what this means. So, for example, the direct award, making sure that people are aware of what is going to change. In terms of timing, one of the questions in the chat is about, well, could we start processes now? We are seeing a slight uptake in processes with people wanting to do things before the 24th of February to stay under the existing rules rather than waiting for the new ones. But the other thing to think about here is, depending on what your timeline is, you may not need to be thinking about the Procurement Act until later in 2025, even 2026, depending on how your organisation procures most of its activity. one of the things that's going to be really important is to make sure you update your standard documentation. So any documents that you have internally around how your processes work. So your SFIs, your procurement policies, they are going to need to be updated to reflect the Procurement Act. We've seen some that haven't still been updated to reflect the PSR. So we need to make sure that those are updated, and we're doing some work on that for organisations if you need any assistance with that. The standard documents, you've got the help from NHS England with what's being published, so they are ones that can be used, and obviously if you want any input on those, give us a shout. And then preparing, making sure you're ready for the notices and the contract management that's going to come in. As Helen said, contract management is a big change here. It's something the NHS traditionally hasn't done a lot of. Management tends to happen when things have gone really quite badly wrong. And so that is something to keep an eye on, but we fully appreciate there's a resource issue here that you're trying to reduce costs, but potentially need more people to manage contracts. Just to try and summarise where we've got to, this is very much evolution, not revolution. So procurement is not being thrown out of the window on the 24th of February. You're still going to have to advertise, you're still going to have to run processes, you're still going to be able to have an audit trail, justify your decisions, etc. What is changing is the detail. I'm saying it again, I know, but the devil is in the detail here. You need to make sure which regime applies, the details of that regime, what is expected in that regime, and make sure you are keeping up to date with any of the changes. So be careful, as I said, of hard copy documents that are likely to be circulating. The thing I think is procurement is going to take longer to start off with. Any procurement under a new regime does take a bit longer because you're finding your way around it. But I think the risks of challenge are likely to be in similar areas. So Maria talked about assessment summaries. One of the things we do at the minute is fight tooth and nail not to give the contemporaneous evaluation records to the unsuccessful bidder during the standstill period. With the assessment summaries, you're going to be putting it on the plate for them. If your assessment summaries aren't up to scratch, they're not sufficiently detailed, they're not sufficiently compliant, then you're effectively giving the ammunition to the supplier to shoot you with. Have your documents updated. Think that transparency is the key for everything here. It's transparency by default. Everything that you're doing is likely to end up with a notice in some way, shape or form. So think about that. But remember that procurement is and will continue to be a question of risk. Now, we know that organisations take risk assessments every day as to the level of detail and effort they put into particular procurements. I think the thing to stress is that under the Procurement Act, suppliers will be looking at what you're doing very carefully to see if you're complying with the rules. You'll be learning what you can and can't do under the rules, so the risks of challenge are potentially greater in the immediate future. You look, for example, in the PSR, we're starting to see more representations now as people are getting into it and decisions are being made under it. So this is it's going to be quite an exciting journey for everybody. Nobody has run a procurement under the Procurement Act. The first people to do it, we know we've got some starting in early March that we're advising. They're going to be the trailblazers for everybody. Everyone will eventually be using the Act as everything else tails off, but please remember the distinction between the Act, the PSR and the PCR. So, questions. Amy, go for it.
Hi there. For the pipeline, should the pipeline, when you're advertising it out, should that include extensions or just the initial term? As because the extension is not guaranteed.
You mean in terms of, does that make it above 2 million?
Yeah, it's sort of working out because some of ours might not be above that, so might not be in the need to be advertised as a pipeline, but possibly with the extension it might be.
So I would like to go. I would like to go away and check.
Yeah.
But off the top of my head, I would say you need to include the extension because, of course, if you were to use it, then that would mean that that was part of the contract.
Okay. And I've just got another one. Rebecca asked me to ask. What happens if our internal SFIs conflict with the Procurement Act 23? Because I think we've had it. She said there was something advertised for the PCR regs as well as to how to deal with that.
Well, I suppose the starting point is you want to make sure that your SFIs comply with the Procurement Act. Ultimately, your SFIs are what you're doing internally The Procurement Act is the law that applies. So the challenge would come against the Act, not against your SFIs. So you'd want to make sure you're complying with the Act.
Okay, thank you.
You will obviously need to keep your audit committee on side on that, hence why you want to update your SFIs.
Thank you.
Okay, Joy.
Thanks, Andrew. Yeah, it's just following up something I put in the chat about below threshold, to just get in my head clear what we need to do for below threshold, because my interpretation is that if it's over 30,000 whole life contract, we put that out on the central digital platform as if it's like a tender, but it's with looser timeframes and things.
So what you're doing is you're highlighting an interesting point, Joy, because of course you're from an ICB, therefore your threshold as your subcentral contracting authority is 30,000 inclusive of VAT, whereas if you are a trust or a foundation trust, it is 12,000 inclusive of VAT. There then is the gap between that amount and the threshold, and that's where the below threshold procurement kicks in. So you need to look at what's required in below threshold.
Yeah.
So what someone's asked about the commencement of a procurement. I see various people have looked at answering that question. If you look at the transitional arrangements, it sets out a contract notice is effectively what needs to be published. And as someone I think has rightly pointed out, unless you are, or the ability to use a PIN as a call for competition was got rid of a couple of years ago following a trade agreement with Australia and New Zealand we entered into, so you shouldn't be doing that in any event. In terms of there's a question here about CPV codes for the provider selection regime. Just to be clear, so if you are a relevant authority procuring relevant healthcare services, you do not want to even be looking at the light touch regime in the Procurement Act, because you are applying the PSR. So what the light touch regime, which has the CPV codes in the Procurement Act, is for anyone that is not a relevant authority that is procuring anything that falls within these CPV codes. Please don't get them muddled up. So make sure you are looking at the light touch regime if you are not a relevant authority. If you are a relevant authority procuring relevant healthcare services, please look at the PSR, because that is where the law that applies is. So National Procurement Policy Statement, I still have to say I've not read all the words in it, so I need to look at that before we can address that. The Central Digital Platform apparently is ready, and if there are webinars that have been produced by Central Commercial Functions setting out how that will work. We've got the scored questions in an open tender or just compared. So yes, you'd have scored questions in either. My understanding is that find a tender is remaining for a period of time, because of course there will be notices that need to go on it. So we'll just have a look at those. I'm not sure, Alison, I understand your question. What are the thresholds for making a direct award? So perhaps we could look at that separately. If you're awarding a direct award under a framework, there is no requirement to have a standstill, but you can do if you want to. So how long should you leave between transparency notice and the contract award notice? So I assume that's in relation to direct award. You'd need to make sure you're complying with the rules that are set out in terms of the standstill. There's a question here about waivers still being allowed, and I think this is just something to pick up, that waivers don't waive procurement law, they just waive your standing financial instructions, which is why when you are considering whether or not you agree to a waiver under your standing financial instructions, you've checked that it actually is compliant with procurement law. So if, for example, you are waiving your standing financial instructions because your requirement is urgent, you would still be capable of being challenged under the Act or the PCR, or indeed the PSR, if your requirement is not actually urgent. So it doesn't matter that you've waived your SFIs, there's still that the legal position that you need to consider. So, we've got a question about horizontal integration example, which effectively is a replacement for well, vertical and horizontal is Hamburg and Teckle. So I'm not sure there is anything, but I would need to go and double check. Diane, you've got your hand up. Sat there patiently.
Yeah, I don't know if it's in relation to one of the questions that you sort of like said. I forgot what you said now, but anyway, it's about the 30,000. So when you're talking about a £30,000 contract, is that a £30,000 contract? So a lot of things in our trust that are £30,000 don't come anywhere near procurement. So a PO, for instance, for £35,000, should we be doing a direct award notice for that?
Well, so your trust, therefore, your gap is between 12,000 inclusive of VAT and the threshold. So you'd fit within the below threshold requirements. You'd have to decide whether or not you were advertising it, and if you were, follow the below threshold requirements. Give me a shout afterwards if you want to go through it, Diane.
So I think that's going to be a lot.
Yeah. Where the excludable supply is going to be, that's going to be on the debarment list. So Joy, take the floor.
Yeah, just one more quick one, please. Just picking up on that. What you just said was you can choose whether you advertise it or not, but in choosing not to advertise, can we choose not to advertise in that regulated below threshold window? Because I didn't pick that up, that was an option, unless we felt possibly it met the direct award criteria, which I think is going to be very few and far between, really, realistically. I don't know whether
like she wants to come in, so I'll let Helen come in.
Thank you.
I look like I wanted to come in? So the answer is it's not very clear. It's not very obviously set out in the Cabinet Office guidance on below threshold contracts. But yes, you can do a direct award. You still will have to comply with some of the requirements, though, like publication of a contract details notice after you've awarded it.
But there's no pre-notice then. Okay, because I think we're taking the view that if it was, right, okay, I thought well, I think we'd harshly misinterpreted that then, that anything over the 30,000 was going to have to be advertised as an opportunity.
I mean, that is subject to your own internal policy and your SFIs, of course. So if you've got something contrary in there, then you would probably want to comply with that.
We're going to be rewriting them against the legislation, won't we? But it's it's just about interpretation. I've read and reread in the 672-page learning manual again, and all of it. It's like it feels like it's leading you down that path of advertising the opportunity, and there wasn't much discretion about that.
And that's where I think, Joy, you need to look at each of the examples and work through it and look at what your organisation wants to do. In one way, you're, as an ICB, the majority of things you'll be procuring are relevant healthcare services, and therefore the PSR will be the primary source of your
absolutely
your procurement. But
there's a lot of digital stuff. We do lots.
You'll still need the Act. But yeah, okay, Kimberly.
Okay, no, thank you.
I think below threshold is a key subject, isn't it? But I read into them that unless it's a pre-select list of suppliers, like on a framework, then you could advertise if you don't know, a group of providers that you want to invite, kind of thing. So we were working on the basis that we may advertise some below thresholds, inviting suppliers to bid where we don't have a pre-select list of suppliers. I don't know whether that's right or wrong, but that was our interpretation.
I think what we're getting from this is we need to do a specific session on below threshold contracts. Thank you all for staying on. Sorry, overran a bit. I can now use my old catchphrase, given everything is changing. So in true Crime Watch style, please don't have nightmares. If you do need any help, please give Helen, Maria, or I, or the rest of the team a call. Thank you all for joining us, and hope to see you soon.